Welcome back to the Crypto's Key conversation. Hey, there's a lot I want to get through in this video, but I know there's a lot going on with the geopolitical stuff, and we're going to cover that in a later video today. But today, in this current video, I want to go over what James K. Flynn had posted with the motion that was denied by the judge, and we're going to go over a couple of Johnny Deaton's threads here. But quickly looking at CoinGecko here, we're currently sitting at a $1.68 trillion market cap, currently down 9.8% for the day. So I'm not going to go down and look at the top 10. We're just going to look at Bitcoin here. Bitcoin sitting at 35,813. If we come over here to the Bitcoin Fear Greed Index, we're still in this extreme fear range. And quite honestly, I wouldn't be surprised to see this drop down more when this thing updates. It updates in 8 hours, 28 minutes, and 30 seconds. So there's a lot going on right now. But just kind of looking at the SC versus Ripple case status and update, kind of see what's going on. James K. Flynn Filan had posted this. It says, breaking. In a one-word order, District Judge Torres has denied this SEC's motion to file a cert reply in the support of its motion to strike. So looking at this, just one word, denied. So this is super awesome that they were denied this. So we covered what they were talking about, the cert reply yesterday. Coming over here, Johnny Deaton had a response to. He said the SEC asked to file a cert reply to cite a fellow district court judge's ruling from a different circuit, striking an entirely different defense while not striking the substantially similar defense that's in question. The SEC should apologize to her for having to type denied. XRP Crypto comes down here. He says Judge Torres gave a one-word reply to deny the SEC. Love how she gets straight to the point with a laughing emoji. So yeah, so clearly that motion was denied by Judge Torres. Coming over here, Johnny Deaton put up this thread we're going to take a look at real quick. He says, thank goodness for Jay Clayton. Says Ripple, Chris Larson, Brock House should all thank Clayton. Clayton is on video with Drunkfest starting at 41:30, explaining how he likes to go after individual executives because it changes the dynamics of the case. So just like I covered yesterday, we were covering this talk with digital asset investor Johnny Deaton, and he was talking about how it's crazy how if there wasn't any forgot what the word was, but if there wasn't anything pertinent to Chris Larson and Brad Garlinghouse as executives, if there wasn't any, I think it was fraud, then how are they apart? Like how did the SEC, go after them? Why did they attack these executives? And he's kind of going through a thread here. So let's take a quick listen in to what our former chairman Clayton says here.
Directly and then by means of anecdote. I believe in individual accountability in the enforcement space, if that's what you're asking. I think it has a greater effect going forward than diffuse corporate responsibility. Corporate responsibility is part of our enforcement regime. It should stay part of it. But when I was in private practice and people would call me up and they would say, hey, what do you think about this? And I wanted to tell them, you know what? I wouldn't do that. I wouldn't pick XYZ company. I would pick a person who had had an enforcement action. Because pointing out a particular person who had gone the wrong way was a much more effective way to communicate the message because people remembered it.
Let me ask you a question, Jay.
So you heard it there in his own words. He literally just said that. So coming down here, Johnny Deaton says, Grunkfest, being smarter than Clayton, cautions that when you go after individual executives, it shifts a much higher burden on the SEC. Clayton's response to that is, yeah, but it might be worth it. In a non-fraud case, it is simply not worth it, nor should you bring it. If executives engage in fraud or mispresentation, they should be sued. The SEC investigated for 2.5 years and didn't find one instance of fraud or misrepresentation. You can bet if you would have charged fraud, you could bet if it would have charged fraud if it could have. Despite no fraud, Clayton filed versus the two executives. You can go back to February 2021 and read my tweets stating, I believe charging Brad and Chris with aiding and abetting was the biggest mistake the SEC made, and that was further proof considering the SEC had zero chance of proving it. The lawsuit was used as a weapon. So we covered that in his interview that he had with Digital Asset Investor. So he was Johnny Deaton was pretty much saying that the case was pretty much dead on arrival. The case was over before it was filed. So he was saying that they used this as a weapon to kind of slow down what was going on with Ripple and XRP. So coming over here, it says, Because it filed aiding and abetting claims against the two executives, this case was no longer a straightforward strict liability securities violation case. Without the executives in the case, there would have been no recklessness standard being applied. It was a terrible mistake. Mistakes are made when the motions behind the lawsuit isn't about enforcing securities laws, but something else. When the people behind filing the lawsuit leave after the case is filed, maybe they don't care about actually winning the case. Maybe filing the case was the damage. Texas Mike said, in the video, as an action SEC chair, describing this harassment tactic as well. So then Johnny D says, then she and Clayton should be aware that it, oh, he was talking about Senator Heron Lee. He says, then she and Clayton should be aware that it is bullying tactic that backfired. If there's no fraud or misrepresentation, then you should not use the individuals because it increases your burden of proof. So there you go. Just more, more video footage of them, speaking in their own words, using facts. So Joseph Hall was saying that the XRP community has unfounded speculation and it's conspiracy theories, but then you kind of look at, these individuals in their own words. That's what we pull up. That's what the timeline is it isn't any speculation. It's facts of them in their own words. Continuing on here. So we were talking about this in our previous video yesterday about how crucial this interview was with digital asset investor and John Deaton here. I just want to listen to this last part here that he's talking about.
If they are leading the SEC and the SEC is the world's greatest expert in what is or isn't in security, if the chairman and the director of corporation finance don't tell you that it's a security, then it's not a security. The point being is that it wasn't even believable to Chairman Clayton or Hinman that XRP was a security. And if it's not clear to them it's a security, just like their SEC enforcement lawyers in their XRP memo, if it's not clear to them, how could it be clear to these two executives?
Here. So, I mean, that's the truth. I mean, how can you expect anyone, even the investors that invested in XRP that you so-called claim were in a common enterprise with Ripple, how can you expect anyone to know if XRP is a security or not if they didn't even know? They still don't know. The SEC still isn't, all members in the SEC still aren't on the same page in regards of, XRP security status, which is crazy. So coming over here, make sure you go and watch his part 1 and part 2. It's a great interview. But Digital Asset Investor has said, while Gary Gensler calls crypto the Wild Wild West, it's the SEC that's acting lawless. 1 minute tell a judge it's a personal opinion, and the next tell a judge that it's an opinion of the division of the SEC. Then change it again. Gary Gensler's need to turn in his badge. So he's talking about how they're claiming William Hinman's Ethereum free pass speech was his personal opinion, but then whenever the judge had, I think it was Judge Netburn had said that they need to release the drafts or the emails of the drafts that was regarding William Hinman's speech. So like, what was the makeup of it and where did it come from? Once they were once they were told to to present that to the courts and to Ripple, now they completely flipped their script again, saying, "Oh well, it wasn't his personal opinion. There's some DPP involved in there, and this was part of our division." Our division within the SEC. I think it was like corporate finance deliberation stuff. So it's like you're kind of talking on both sides of your mouth. You're contradicting yourself. So that's what he's bringing up right there. Johnny Deaton is responding to Ryan Selkis's tweet here, which I thought was interesting. It says the CFTC should have an oversight over the crypto spot markets unless the SEC proves that the facts and circumstances make a given token a security. If a token is a security, that's fine. The crypto exchanges can list it separately under their in-house ATS, common sense. So if you come over here, he says, it sounds like super jargony and uninteresting, but if it weren't for a year of bad faith, technical incompetence, and an out of control SEC chair, the solution would protect investors, improve market integrity, and ensure the U.S. remains a financial and tech leader. So coming over here, Johnny Deaton says, because Congress is unlikely to act in time, I hope to be proven wrong. The best thing that can happen in this for the judge to declare today's XRP a non-security in a way that provides clarity for all existing alts. This is huge. This case can truly set precedent for the entire crypto space. He says XRP to be declared by the judge to be a non-security in the way that provides clarity for all existing alts, thus leaving the SEC jurisdiction only in pure ICO scenarios. That would be absolutely ideal. So coming over here, I want to check out this one as well. So this is from Library. Library is undergoing an investigation or a lawsuit with the SEC as well. They said the SEC just said in a verbal argument in our case that they have not asserted that Bitcoin and Ethereum is not a security. They are saying that him in speech is his personal opinion. So obviously we all know the contradictory talk that they have. He says, this from Bill, it says, this again shows the validity and correctness of what Johnny Deaton has said for over a year in the class action lawsuit. If the SEC wins against Ripple, all of crypto is at risk. If the SEC wins against Ripple, all crypto is at risk. And that's so important. That's so true. And I just wanted to cover these as we end. I thought these are massive. This is Martin Lewin. This is the timeline, and it's in this nice infographic, kind of talking about all members in the parties. It got the dates, timestamps, and what was done. This is absolutely massive. So make sure you go in and like and retweet this, and then you check out this timeline to kind of update yourself on what's going on. And then I like this one as well. Obviously, this is growing day by day, but this is a class action lawsuit with Johnny Deaton. Obviously, it's over 65,000 holders now, 56.2 in the U.S. International. Look at the international contributing, 80 countries. It's absolutely massive. You talk about XRP being a security. Look how decentralized the community is. I mean, this is crazy. All these people coming together for a common cause, for the truth and what's right. There's a lot going on. We got a couple more videos coming out. I want to cover a couple more things of what's going on with the SC versus Robo case, and then there's a lot going on with the geopolitical side of things when it comes to the effects of our markets with Russia invading Ukraine and what's going on with inflation, Jerome Powell, and the Fed and stuff. So we're going to have a couple of videos that's going to come out, kind of touch on everything. But I just wanted to say, with all this, this extreme fear out in the markets and our markets being down 10% for the day, just, try to, hold on strong out there. And just like I always tell you, stay safe out there, stay strong out there and be safe.